if someone has seen an armed robbery and wants to talk to the police, or if someone was raped and wants to report that to the police, many agencies say we won't investigate their immigration status. If a law enforcement agency were to do that now and say, the chief were to say, or city council were to say to the police department, don't investigate the immigration status of victims or witnesses. Well, you ask, is it prohibited under federal law to investigate the immigration status of victims or witnesses? No. No law says you can't do it. No law says you have to do it. But since it's permitted by federal law, then a state policy prohibiting it is prohibited. So the agencies can't restrict the conduct of their line employees. And that provision is enforceable by citizen suit. Actually, not citizen suit, resident suit. So any lawful resident of Arizona can sue an agency or official that violates that and collects damages and attorney's fees, although the damages go to a state agency. The federal court allowed that to go into effect, and it's in effect today. The SB 1070 creates 4 new crimes. It's the third thing it does. It copies federal law to the extent that it says that if you are a non-citizen, you have to carry your immigration documents with you. That's already a requirement of federal law. Now it's a violation of Arizona law as well, except that part was enjoined, and the judge did not let it go into effect. Another crime is created by SB 1070, makes it an offense to work if you're unauthorized. And that's not a crime under federal law. It is a crime under Arizona law. That was enjoined. The third crime, which is not tied to immigration status, it applies to everyone, makes it a crime to solicit work or accept work or hire someone while blocking traffic, which is aimed at day laborers, but it doesn't just apply to day laborers. For example, now it's going to be applied to street solicitation of prostitution. Not enjoined. That's in effect today. The most interesting statute to me is a statute which kind of was already on the books in Arizona and kind of is already on the books in 6 other states. It makes it an Arizona crime. It's loosely based on a federal statute. Makes it an Arizona crime to transport, move, conceal, harbor, or shield an undocumented non-citizen in furtherance of their unlawful presence in the United States. And this has 2 sort of general possible meanings: transport, conceal, harbor, shield, move, in furtherance of unlawful presence. One is that it could apply to the actual process of immigration, smuggling people across the border, hiding from law enforcement authorities, bringing them to a place in the United States to work. The other possibility is that it applies to everything. Because if you know, in a broad sense, right, is giving someone a ride to the supermarket in furtherance of their own, is it transporting them? Well, sure. Is it in furtherance of their unlawful presence in the United States? Well, they can't stay here if they can't eat, right? So, in a sense, it's in furtherance of their unlawful presence in the United States. I think the broad meaning was intended here by the legislature. Why? Because there's exceptions. And the exceptions are for child protective services workers in the performance of their official duties. They're not liable. And first responders working for licensed ambulance companies. So they come across somebody on the street, put them in the ambulance, drive them in the hospital. They're not guilty. Okay? The child protective services worker takes somebody to juvenile hall. They're not guilty. But the idea that that otherwise might be in furtherance of unlawful presence, or otherwise is, suggests that it's very broad, very broadly intended. And studying SB 1070 because there were a lot of things about SB 1070 that I thought were misdescribed in the media, both by critics of SB 1070 and defenders. And I want to tell you a couple of them. SB 1070 does not authorize or allow the police to stop people just to check their papers or to stop people with no evidence. It would clearly be unconstitutional for a statute to authorize the police just to stop people to check their papers. On the other hand, with or without SB 1070, the police can ask you any question they want at any time, and if you choose to answer, that's your problem. So before SB 1070, they could just go up to anyone they want and say, "Excuse me, are you undocumented? Excuse me, are you carrying weapons or drugs?" And if you answer in the affirmative, that's perfectly admissible. But that phenomenon that the police can go up to anyone they want and ask it anything they want has nothing to do with 1070. SB 1070 also doesn't really affect the involvement of, or at least this isn't the beginning of the involvement of Arizona police in immigration law enforcement. For 20 years, there's been case law, court decisions that say that local police can make arrests for criminal violations of the Immigration and Nationality Act. So for criminal immigration offenses, before SB 1070, local police could arrest based on probable cause. If a criminal violation being something like re-entry after deportation or human smuggling. So they could and did do that. They also, local police in Arizona, cooperated with Customs and Border Protection and Immigration and Customs Enforcement officials before SB 1070. So what that means concretely is that almost anywhere in the state of Arizona, if you were pulled over based on probable cause that you committed a traffic violation and you're getting a ticket, and the police thought that maybe you were undocumented, they would say, "Are you undocumented? Do you have a visa?" And if you answered in such a way that gave them a basis to think that you were undocumented, they would say, "I'm going to have to call Immigration and Customs Enforcement, and I'm going to wait here. If they can get here within the next 20 minutes, I'm going to keep you here for them to get here. And if they can't get here within the next 20 minutes, I'm going to let you go." So they were the sort of muscle. They were helping out Customs and Border Protection and Immigration and Customs Enforcement for years before SB 1070. Also the case that almost everybody who was arrested in Brooklyn County Jail in Arizona had their citizenship checked, and if they were undocumented, they would be reported to the federal immigration authorities. So there was already an enormous amount of cooperation between local law enforcement and the federal authorities before this. So what's new about SB 1070 is that before, if local police wanted to make an arrest, they would have to turn the person over to federal authorities. And federal authorities generally would not, that is to say the U.S. Attorney's Office for the District of Arizona, didn't really have an interest in prosecuting the average person. And so, that is to say the average strawberry picker, alfalfa picker, who was here without authorization. And so that was sort of a futile gesture to make arrests of undocumented people and turn them over to federal authorities. Now they can process them through their own system, the state criminal justice system, and it's much more likely they will wind up in deportation proceedings. Another issue with SB 1070 is the racial profiling question. And this is, the defenders of SB 1070 have insisted that it doesn't involve racial profiling. And by racial profiling, I don't mean